Next case set for argument is State of Ohio versus Darius Ramey. It is case number 18CA011331. Both parties are represented by counsel. So each of you will have 15 minutes to present your oral arguments to the court. The appellant may reserve up to 5 minutes for rebuttal. If you're going to reserve time, let me know and I'll keep track of it up here for you and let you know as you get close. We use victims and children's initials as opposed to names during the argument, since it is recorded and posted on the YouTube channel. We use the front podium and ask that you stay at the podium, keep your voice up to help that recording. With that, I'll mention that the panel has read the briefs in the matter, and we are prepared to proceed if you are. Counsel.
Thank you, Your Honor. Good morning, and may it please the court. My name is Victoria Bader, and I'm counsel for appellant Darius Ramey. I would like to reserve 5 minutes for rebuttal.
I'll let you know when you get close.
Thank you. As a preliminary matter, I would like to concede the first assignment of error. As part of his plea agreement, Darius did stipulate that counts 1 through 3 are not allied offenses of similar import. The inclusion of that argument was an oversight on my part. With that matter aside, I do plan to focus the remainder of my time on the remaining assignments of error. Contrary to the state's position, we are here today to enforce Darius's plea agreement, a plea agreement that included common sense safety valves to allow for correction of unintended errors. Here, the trial court committed 2 errors. First, it failed to specify a specific number of days of jail time credit in the sentencing entry, despite an agreement that he received credit for all time served as required by law. And second, the court imposed court-appointed counsel fees without notifying Darius at his sentencing hearing. And for those 2 reasons, I asked this court to reverse and remand his case to the trial court. The Ohio Revised Code mandates that as part of the sentencing entry, the trial court must include a number of days that the offender was confined related to his case. In the event of a juvenile bindover, like in this case here, confinement includes time held in both the juvenile detention center and the county jail. DRC then uses the sentencing entry to reduce a defendant's prison term by the number of days calculated by the trial court in that entry. And the Ohio Supreme Court has held that errors related to jail time credit may be raised at any time, even if not raised at the sentencing hearing. And this court has recognized in State v. Clark that a court's failure to properly indicate a specific number of days constitutes reversible error. And in that case, the trial court merely awarded credit for time spent as agreed by the parties. And this court reversed, finding that it was troubling that if the parties had agreed to a number of days, that agreement was not reflected anywhere in the court entry or the transcript of the hearing. Like the appellant in Clark, all parties in this case agreed that Darius was entitled to credit for all time served. Specifically, the planned sentencing agreement said that Darius was to receive credit for all time served as required by law. Despite this, and despite the court's statement that Darius would receive credit for all time, the sentencing entry just merely said all time, or all days, with no specific number.
Is that your argument as to the state's argument that these issues were waived because there was no objection?
So, Your Honor, I don't think that this is waived because there was no objection. Certainly, I know that the state pointed out that there was nothing for counsel necessarily to object to because the court did say credit for all time served. And the error actually occurred in the judgment entry. It certainly would be best practice, and I argue that counsel was ineffective for not ensuring that that specific number of days was put in the sentencing transcript and presented to the court. However, in this case, Darius is actually trying to enforce his plea agreement. The plea agreement specifically said the number of days as required by law, and the law requires a number of days to be in the sentencing entry.
Has anyone made a request to the trial court, started there, to get this issue taken care of?
Your Honor, I actually did, in this case, file a motion for stay and limited remand very early on in the proceedings. That motion was denied. And so this is also something that can be resolved through the trial court, but because we are on direct appeal, I think it needs to be raised at this time and can be remanded to the trial court. But effectively what happened here is, because Darius didn't receive that specific number of days, there is no way for DRC to reduce the number of days. They rely on that court entry, and effectively, Darius's 21-year sentence has turned into a 22-year sentence without any direction from the trial court. And accordingly, Darius did not receive the full benefit of his plea agreement. He was supposed to receive 21 years less jail time credit, which in this case was more than 600 days. That's a substantial amount of time that Darius potentially could be missing, and he simply is trying to enforce his plea agreement in this instance. Additionally, this court and other courts have also found that a trial court cannot impose court-appointed counsel fees without first considering the defendant's ability to pay, and second, notifying the defendant of the imposition of court-appointed counsel fees at the sentencing hearing. In State v. L. Jones, this court found reversible error when the trial court imposed court-appointed counsel fees in the sentencing entry for the first time without orally informing the defendant at a sentencing hearing. That's exactly what happened in this case. And specifically in that case, this court found that it deprives the defendant of his opportunity to claim inability to pay based on indigency. Here, Darius's plea agreement was completely silent regarding fees, and there was no mention of it at the sentencing hearing whatsoever. The first instance was in that sentencing entry. Further, that prevented him from the opportunity to assert his indigence and his lack of ability to pay. The record here is actually insufficient for finding of ability to pay, just based on the limited record we have. As a result of his plea agreement, he agreed not to have a pre-sentence investigation report. So there is no information about his work history, no detailed information about his educational history, no information about his financial status. The record does show that he was 16 years old when this case started in the juvenile court. He was 18 years old when he was sentenced. He had court-appointed counsel due to his indigence. He had not completed high school, and I believe at sentencing he said he didn't go to school a lot. And the only question the trial court asked for purposes of restitution was whether or not he had any physical or mental disabilities that would prevent him from working, to which he responded no. So first, because the court failed to notify him, I think that's a dispositive error in this case. But also, I don't think that there's a sufficient record for a finding of ability to pay either. That's a reversible error in this case. And Darius asked that this court reverse and remand that matter to the trial court as well.
You're asking that the plea agreement be enforced, but in the plea agreement, wasn't there a waiver of appeal?
So there was a waiver of, so there are a couple different clauses. This is a pretty long plea agreement. It was about 7 pages. And there were certain safeguards that would allow him to appeal in very specific circumstances. One of those circumstances was kind of a blanket catch-all provision that said he would waive his right to appeal outside of prosecutorial misconduct or ineffective assistance of counsel. And that was only if he receives the benefit of his sentence agreement. So regarding the second assignment of error here, the jail time credit, my position is that he did not receive the full benefit of that agreement, which would allow him to appeal outside of that provision. And anyway, but he did raise this under ineffective assistance of counsel as well, just to make sure that he is appealing this in the appropriate fashion. And then regarding the third assignment of error regarding the court-appointed counsel fees, the plea agreement specifically referred to his sentence and conviction. Fees are not a part of the criminal conviction or sentence. They're separate outside of that specific punishment. So that wasn't specifically discussed in the plea agreement. My position is that Darius can raise that at this time because that wasn't specifically waived.
Thank you. No questions.
I'll reserve the remainder of my time. Thank you.
All right, you will have a full 5 minutes for rebuttal. Counsel, as you know, you have 15 minutes.
May it please the court, Lindsay Cropper on behalf of the state of Ohio. The state views the issues in the appeal from a very different vantage point. The issues in this appeal from the state's view center around the impact of a negotiated plea and sentencing agreement, which had a significant effect on Darius Ramey's sentencing, whereby he received a considerable benefit in exchange for waiving the right to appeal the sentence he now challenges. Prior to entering his plea, Darius Ramey was charged with 2 counts of murder, each of which carried a potential sentence of 15 years to life in prison. As part of Darius's plea agreement, the state agreed to amend the indictment to remove 2 counts of murder and remove the life tail as a potential sentence. There is no dispute in this case that the negotiated plea and sentencing agreement provided for a jointly recommended sentence of 21 years in prison.
Wouldn't it also include jail time credit?
It provided a provision for Darius to receive jail time credit for all time served. That is the provision that it provided for.
And you would agree he's entitled to all time served in juvenile detention
Correct.
and the adult?
Yes. There's also no dispute that the sentencing agreement contained an express waiver which provided that Ramey would not pursue appellate relief or otherwise challenge his sentence.
How does he get relief then? I mean, he's entitled to the jail time credit. Nobody's disputing that. Department of Corrections is not going to give it to him unless it's in the entry.
We're submitting that he waived his rights to appellate relief in the sentencing agreement.
Isn't
And
that
the sentencing
ineffective
agreement-
assistance of counsel then?
I'm sorry?
Isn't that ineffective assistance of counsel then, that you're not, file a motion with the court or not pursue this defendant's right to receive proper credit for time served?
We cited a case in the brief under the ineffective assistance of counsel provision regarding that specific claim, State v. Ponyard, where the 8th District, I believe, stated that it was not ineffective assistance of counsel, and it's a very similar case as this, where the judge provided that he would credit the defendant for time served, and he did not provide for the total number of days specifically, but he did provide that credit would be granted. And the 8th District said that was not ineffective assistance of counsel because the defendant was not precluded from time served. And here, again, there is no dispute that the agreement contained an express waiver clause. That the appeal would not be for anything outside of prosecutorial misconduct or ineffective assistance of counsel. And despite receiving the benefit of his bargain, we stand here today.
That's where I'm having trouble. How did he get the benefit of this bargain when he's entitled to credit for that time served and he's not getting it? I mean, the bargain was for 21 years minus the time he was in custody. And opposing counsel is saying he's not getting the benefit of that credit. So how is he getting the benefit of his agreed sentence when he's not getting his agreed sentence?
He is getting his agreed sentence. He's getting 21
Then why are we
years.
here? I mean, your opponent is saying he is not getting credit for time served. You're saying he is?
I'm saying that he agreed to 21 years. That was the benefit of the amended indictment. And he agreed that he would waive all challenges to his sentence.
I understand the argument. It's how it is playing out in real time, I guess, that I'm having a problem with.
To follow up on that, he's arguing that there's no way for the DRC to calculate his time served.
Thank you, Judge.
Are you just, I haven't heard you dispute that. I think what I'm hearing from you is that's not something that we know yet. I mean, what is your response to his argument that there's no way for the DRC to properly count the number of specific days he's entitled to after the resolution of this case? And understanding that it may be unfair to ask you that question, but it's being asked anyway, to get us past this, what he can and can't appeal after this plea agreement.
Okay. I may agree that there is, based on the judge's statements at sentencing, when he says all time served, there's not a number for DRC to work with. Does that answer the question?
I think so.
Okay.
But yet, it's my understanding that your argument is you still dispute that whatever credit he gets means he still got the benefit of his plea negotiated deal. The state is not conceding that he did not get the benefit of what his negotiated plea was.
The state is not conceding that he has a right to stand here today.
Okay.
The state is submitting that he waived his right to appeal.
Okay.
Ramey has not challenged that he did not enter the decision that he entered his decision to the agreement to waive his right to appeal knowingly and voluntarily. Here the state also properly filed a motion to dismiss the appeal prior to filing its merit brief. And today, just today, prior to oral argument, the Ohio Supreme Court issued a decision in State v. Gwynn, that's 2019 Ohio 4761, concluding that where a plea agreement concluded a waiver of right to appeal, but the state did not ask the Court of Appeals to dismiss the direct appeal on that basis, or mention that aspect of the plea agreement in its merit brief, it forfeited the issue of waiver. However, the Supreme Court of Ohio opinion goes on to state that had the state of Ohio filed a motion to dismiss before briefing commenced, a favorable ruling on that motion would have prevented the appeal from going forward. That's our position here.
Was
We
ineffective assistance of counsel raised in Gwynn?
Your Honor, I believe that I'm not completely clear as to whether ineffective assistance of counsel was raised. I know that the state did not raise the waiver issue, and the Court of Appeals raised it sua sponte, and then they indicated that the state had waived that, forfeited that issue because they had not raised it on their own. Here we're submitting that the agreement between the state and Ramey should be enforced because he waived that right to appeal by expressly agreeing to those waiver clauses where he said he would not provide for appellate review or challenge his sentence. Now, apparently today, he has conceded his first assignment of error regarding merger, and we've discussed his second assignment of error regarding the jail time credit, which, however, we would assert that there was no objection to the jail time credit issue at sentencing, and therefore the issue would have had to have been raised on appeal for plain error. And in the appellate brief, there was no mention of plain error. The issue of plain error was not raised by appellate counsel, and this court should not sua sponte raise and make a plain error argument on behalf of the appellant. As to the ineffective assistance of counsel argument, Ramey has asserted that he could not raise this ineffective assistance of counsel argument in a vacuum. And in essence, the state is asserting that this is the only argument that Ramey could have raised due to the waiver clause. It's the only assignment of error that, if before the court at all, is proper. However, his assignment of error fails on its merits. We had included a argument that counsel cannot be ineffective for agreeing or for failing to object to an agreed sentence. And here that's what counsel did. It agreed to the sentence that was provided for in the sentencing agreement and plea agreement.
Well, it wasn't provided for in the judgment entry.
I'm sorry.
He agreed to a sentence that was not accurately reflected in the judgment entry.
Are you referring back to the jail time credit?
Yes, it is.
I'm pretty transparent here with what I'm concerned with.
I see that. And again, we would cite to the case of State v. Pioneer on this jail time credit and the ineffective assistance of counsel claim. The trial court did indicate that it would provide for jail time credit. He did provide that he would grant jail time credit even though it was not for the total number of days. Overall, the state submits that we should not be standing here today based on the waiver clauses in the sentencing agreement and the plea agreement. Ramey has waived his ability to stand here today and assert the assignments of error he asserted in numbers 1, 2, and 3. It was a voluntary and knowingly unforced waiver of appeal rights. Those have been held to be enforceable in, I believe, Butts and Bethel. The agreement should be enforced, and there are no other questions.
I guess I have one. Proceeding on the idea that everybody's role here is to do justice, if we were to accept your waiver argument, which would basically be we don't even have jurisdiction to hear this appeal, what's his remedy for those 600 days he didn't get, assuming that that's even part of a record that we would have to look at if we looked at the record?
I don't know if the appeal is dismissed to go back to the trial court. I don't know if that's possible.
If I knew the answer, I wouldn't ask you. But, okay, thanks.
Thank you.
All right, thank you. Counsel, you'll have 5 minutes for rebuttal.
Thank you, Your Honor. I believe that the state sort of conceded that the judgment entry was incorrect in not including a number of days, but the bigger issue that I think the state has with this case is the reason that we're standing in this courtroom right now. This was a very extensive plea agreement. I certainly understand that a lot of time went into this, but there were definitely provisions in this plea agreement that were meant to serve as safeguards for Darius and for the state to make sure that this plea agreement was fully enforced. The provision that the state continually cites to is section 6C that states if the defendant receives the full benefit of his sentence agreement, then he agrees to the following. There's an itemized list. And subsection 3 states that he will not pursue any direct appeals outside of ineffective assistance of counsel. I believe that this permits Darius, 1, to raise any claims regarding ineffective assistance of counsel, including jail time credit. But I also think that it brings him outside of that scope as well, because he did not receive the full benefit of his plea, because it's distinctly said as required by law. That didn't happen in this case, and I think this court can reverse that sort of specific assignment of error on any grounds outside of ineffective assistance of counsel. Regarding the plain error argument, this court has reversed in the past in Clark without conducting a plain error analysis. This is clearly reversible error, and if this court thinks that we can stand here today and make this argument, then I think that this can be reversed without a plain error analysis. I did receive from the state a supplemental authority this morning. Just before I walked in the courtroom, State v. Gwynn was released this morning. I have not had an opportunity to review that. I glanced at it briefly before I walked in this room. If the court would like additional briefing on that, I'm more than happy to provide supplemental briefing based on Gwynn. But that case was not cited below, or in any of the merit briefs, the state's brief either, but I'm more than happy to provide supplemental briefing on that. And finally, regarding Judge Callahan's last comment, what is the remedy in this case? Darius could file a motion in the trial court. We did try to do that at the beginning of this, but because we were in appellate proceedings, and direct appeal is the appropriate place to file this at this time and to make this argument. However, my concern is that if this court's decision is that he actually waived everything, that the trial court would then look at that decision and say, he waived his right to appeal this, he raised his right to any post-conviction relief, and then refused to grant him that credit. If this court is inclined to reverse this or to dismiss the appeal or write a decision that puts the onus back on the trial court rather than making a decision in this court, I certainly think that one consequence could be that the trial court would think that they don't have jurisdiction to rule on it, either based on that waiver. If the court has any additional questions, I'm more than happy to answer them.
I do. I'm familiar with the premise of Clark,
Yes.
but considering it might as well be State v. Smith. Do you have the citation?
I do not in front of me, but I can certainly,
No.
it is in the merit brief.
I'll find it.
I
Got it.
apologize, Your Honor.
No, you don't need to.
If there are
Thank
no
you.
further questions, I'd ask this court to reverse and remand on the second and third assignments there. Thank you.
All right, thank you both for your presence today and your arguments. It's an interesting case. The court will take the matter under advisement, issue a decision in due course, and the clerk of courts will mail you each copy of the decision on the day it is released. Of course, you can also find the court's opinions on the Supreme Court of Ohio's website. And we will next